This content module is for CG13. The Judiciary, Part A. Demonstrate knowledge of the operation of the judicial branch of government. A major weakness of the Articles of Confederation government came from the lack of a national court system, aside from a court dealing with maritime cases. Thus, the only enforcement mechanisms available for violations of the Articles of Confederation were either military action or economic sanctions against a misbehaving state. But because 3/4 of the states were required to approve any such action against a fellow state in Congress, states were reluctant to approve draconian actions enforcing the Articles, because their state might be punished in the future. Additionally, without a national court, the 13 state court systems were the only source for interpretation of the Articles and a state's obligation to follow them. These courts consistently favored the state's power over the national government. Needless to say, states felt punishment for violation of the Articles was unlikely. Because the national government was unable to defend its powers, one consequence was that states ignored U.S. treaty obligations to other countries. Other countries became reluctant to sign treaties with the U.S. for this reason. Likewise, states ignored their constitutional obligation to other states regarding trade, treatment of the citizens of other states, and recognizing their legal rulings. The national government could do little to stop them unless 3/4 of the states in Congress voted to punish a state. Another weakness was that individuals in the state owed no duties or obligations to the national government. Only the state governments could punish individuals that affected national concerns. A circumstance which crowns the defects of the Confederation remains yet to be mentioned: the one of a judiciary power. Laws are a dead letter without courts to expound and define their true meaning and operation. The treaties of the United States, to have any force at all, must be considered as part of the law of the land. To produce uniformity in these determinations, they ought to be submitted, in the last resort, to one supreme tribunal. Federalist 22. In the New York case of Rutgers v. Waddington in 1784, Alexander Hamilton argued the Treaty of Paris and the Articles of Confederation prevented New York state courts from enforcing state laws that contradicted national laws regarding the treatment of loyalists. This led to his later opinions in the Federalist Papers that a national court system was necessary to enforce national laws. CG13a. Describe the selection and approval processes for federal judges. Despite the original plans for the Constitution varying on how judges were selected, eventually the Convention provided for the President to select the justices of the Supreme Court and for the Senate to approve them through the advise and consent provision, just as other nominees are. Justices are to serve for good behavior, which effectively means lifetime appointments. Under the Judiciary Act of 1789 and its subsequent laws, other Article III judges also have lifetime appointments with good behavior. Choosing nominees for the federal judicial positions is one of the most important and long-lasting legacies of a president. As the judiciary has become more prominent in our federal system, the President and the Senate often disagree on what sort of nominees should be appointed to the courts. However, presidents often know that the Senate must vote to confirm a president's nominee, so presidents must take into account how the Senate will react to an appointee. For this reason, presidents often must compromise on who is appointed, and they discuss potential nominees with senators, so that a losing confirmation battle does not occur. Diversity of presidential nominees based on race, ethnicity, sex, and other considerations have also risen in importance as well. Particularly on Supreme Court nominees, the President must ensure that the legal community and the general public do not oppose a nominee, or risk defeat. Since the court system decides so many important issues at the national level, people are naturally concerned who becomes federal judges. The appointment of judges for the judicial branch demonstrates how the separation of powers works in the Constitution. In order to fill positions in the third branch, the President may propose a nominee, but the Senate has the separate powers to advise and consent to that nominee serving. The President can technically appoint who they desire, but likewise the Senate is unconstrained in its power to confirm a nominee. This reality is particularly apparent when the Senate is controlled by the opposite party of the President. Occasionally, the President's nominee may not even get a vote, and the President is forced to withdraw a nomination. The President can risk a temporary appointment during a recess of the U.S. Senate, but that nominee only serves for the remainder of that congressional session. The position becomes vacant again if the nominee is not confirmed by that time. This map displays the geography of the federal court system, with the courts of appeals in color and the district court boundaries noted by dotted lines within states. There are 663 authorized district court judges and 179 U.S. courts of appeal judges in the 13 circuits. Over time, judges for the nation's courts of appeal have become more important. Since the U.S. Supreme Court hears relatively few cases, the courts of appeal exercise a day-to-day oversight over district courts and resolve most of the appeals heard by the federal system. Recently, nominees for the U.S. Supreme Court usually have come from serving on the U.S. Courts of Appeal first. These nominees often represent lower risk for presidents to appoint, as they have already been scrutinized by the U.S. Senate in earlier confirmations. As a result, these judicial appointments have become increasingly scrutinized by senators, and those senators in office within a particular appellate circuit are especially vigilant on these appointees. Senators of the President's party often carry significant influence with the President on these appointments, as well as members of the Senate Judiciary Committee whose support is vital to obtain a floor vote on the nomination. There are 94 districts with 663 authorized judges serving those districts nationwide. Senators, through the exercise of senatorial courtesy, effectively have a veto on presidential nominees not to their liking, if both senators disapprove of a nomination. For that reason, senators often discuss district court candidates for nomination with senators and appoint candidates that do not arouse a senator's open opposition. Recent Senate rule changes that have eliminated the filibuster for federal judgeships at the district and appellate court level will give presidents more latitude on nominees to these positions in the future. Opposition to presidential nominees becomes particularly pronounced when the Senate is closely divided or when the Senate is controlled by the opposing party from the president. The increasing role for federal judges in many policy decisions also means senators are increasingly acting to oppose nominees that are likely to have differing policy positions. The lifetime nature of these appointments leave both parties attempting to control who is nominated and trying to prevent nominees on ideological grounds. This is particularly evident when public opinion and the politicians are polarized on key issues before the courts. Today's nominees to positions face lengthy confirmation hearings, copious requests for answers to senatorial questions, significant vetting by presidents before the nomination, and scrutiny from the legal community. In the end, nominees with stellar legal qualifications have been rejected by the U.S. Senate and sometimes not even allowed a confirmation vote. This flowchart summarizes how nominees are appointed to the federal judiciary. This is the old Supreme Court chamber from 1810 to 1860 in the U.S. Capitol, and was the original Senate chamber from 1800 to 1808. Many important cases were heard here, but not Marbury versus Madison. During 1800 to 1810, the Supreme Court held court in various rooms in the Capitol, and according to some accounts, at Long's Tavern, which was across the street from the U.S. Capitol. CG13b. Explain the jurisdiction of the Supreme Court, the federal courts, and state courts. Jurisdiction is the legal authority for a court to hear a case. Authority for federal cases must be based on the Constitution, treaty, a statute, or other federal action within the federal government's power. State courts' jurisdiction corresponds with authority granted by state laws and a state's constitution. Ultimately, the Constitution in Article 3, Section 2 provides a narrow list of cases where the Supreme Court has the original jurisdiction to hear these disputes. All other cases heard by the Supreme Court under its appellate jurisdiction are subject to the laws of Congress, which may add or subtract jurisdiction to hear cases. A court possessing original jurisdiction has the authority to determine both law and fact through a trial. Appellate jurisdiction in the U.S. limits appellate courts to resolving only disputes over alleged legal errors in the lower court's decision, and appellate courts cannot retry facts found by lower courts. A court lacking jurisdiction cannot resolve that case, as the court does not have the legal authority to decide it. Under the Constitution, the Supreme Court's original jurisdiction is composed of hearing cases involving ambassadors, other public ministers and councils, and those in which a state shall be party. The Supreme Court's appellate jurisdiction involves cases involving the U.S. Constitution, treaties, federal statutes and regulatory actions, ambassadors and other public ministers and councils, maritime and admiralty law, legal disputes between the U.S. and a state, between citizens of different states, and also between U.S. citizens and foreign citizens. This is termed as a federal question, which is necessary for national courts to have jurisdiction. Congress also has the power to legislate the jurisdiction of lower federal courts. State courts still have concurrent jurisdiction involving many federal questions, but are subject to Supreme Court oversight as it is the highest appellate court in the U.S. These are sources for this content module. Sources for images in this content module. Additional resources can be found at these websites. This concludes this content module.